Hey y'all, welcome back to Legally Live. I'm your host, McKinley Molasaw, Austin criminal defense attorney, and today is day 9 recap of the Kaitlin Armstrong trial. And you know what that means? It's the last day of testimony. I'm pretty psyched about that. It has taken me like 8 million tries to record this video. I've had all kinds of technical issues. I've had RSV forever. So I'm sorry I'm late, but thank you for sticking with me. Let's jump on it. Day 9 started off with the state resting their case in chief, which meant it was the defense's turn to put on their case in chief if they decided to do so. In this case, they did decide to do so, and I think that was probably a good choice. We'll have to wait and see. But usually when the defense decides not to put on a case in chief, it's because they have determined that the state has not proven beyond a reasonable doubt their case. And in this case, I think it was evident to anybody sitting inside that courtroom that the state did a phenomenal job of presenting their case. And I had zero doubt at the end of the state's case. So that meant the pressure was really on the defense to give it all they had. I'm not sure that they had that much or could really do anything, but let's see what they did. The first thing that the defense did was call in the senior latent print examiner from Austin Forensic Science Department. This was actually someone who participated in the state's original investigation. It was their print examiner. However, the state did not call her during their case in chief because she had nothing useful to add to their case. And I'm not actually sure, I'm not sure she had that much useful to add to this defense's case either. I'm definitely going to get defense and state mixed up in this because we've been saying the state called for so long, so bear with me. The reason that I believe that the defense is going to be calling this witness to the stand is I think they're trying to show that the investigation was always too laser focused on Kaitlin Armstrong to the exclusion of any other possible subjects, as well as that the investigators or the state's never actually able to place Kaitlin Armstrong inside that apartment, at least not through fingerprints. I know that the state thinks that they were able to place her inside the apartment through the DNA on Mo Wilson's bicycle. However, that bicycle was found outside. So that's something, it wasn't actually inside the apartment. Obviously, Kaitlin has given no reason that she was anywhere or should have ever been anywhere near that bicycle. So could be a problem. Anyway, this witness, we're going to call her Legrone, that was her last name. She explained that she did not collect the fingerprints from the scene. She actually was given the latent print cards from the crime scene investigator or the crime scene analyst who already testified during the state's case, and her name was Ferreira. She was asked by detectives to compare the prints on the cards to Kaitlin Armstrong, and the defense asked her if she was ever asked to compare them to Caitlin Cash's fingerprints or Mariah Wilson's fingerprints, and she said she wasn't. She wasn't ever asked to compare them to anyone else's fingerprints besides Kaitlin Armstrong's. The defense also asked her whose fingerprints were found in and around the door of Cash's residence, and she said she did not know. She explained that the prints that she examined were inconclusive, unsuitable for analysis, or outright excluded Kaitlin Armstrong. The defense asked if she was able to place Kaitlin Armstrong fingerprints anywhere in that apartment, and she was unable to. On cross, the state asked her if she would expect to find the person living in the apartment fingerprints within that apartment, and she said yes. And then they asked if she would expect to find their invited guests' fingerprints in other words, Mo Wilson's fingerprints within that apartment? And she said yes. She said the only time that she would be concerned about fingerprints would be when they belonged to somebody who was not supposed to be in the residence, i.e. Kaitlin Armstrong. They also did something kind of funny here. I don't know if you remember, but during the state's case in chief, Geoffrey Purrier, when he was cross-examining the ballistics expert, he asked 3 different times whether or not Aston had ever failed a proficiency exam. And 3 times this guy said, no, he hadn't. He had gotten a perfect score each time. And I think the reason he was trying to show that, like the reason he kept asking that was kind of to show the jury that like these exams are hogwash. Well, the state asked her if she had ever failed a proficiency exam, and she said no. I think they were just like trying to throw it back at the defense in this case. But as my mama would always say, that's kind of like cutting off your nose to spite your face, you know? I'm not sure that one worked out for them. Finally, the state asked her about using pineapple to burn off your fingerprints, alluding to Kaitlin's prior search history that was already testified to. And she said she had actually never heard of this one before. She had heard like back in training about people using different ways of like injuring their fingerprints to damage them and, you know, create new fingerprints or try to erase their old fingerprints or something. But she said that pineapple is only mildly acidic, and she would assume that you would have to hold a pineapple for an extremely long period of time for it to have any effect on your fingerprints. So next, in the defense strategy, we see them start to question the police interview, and they do this through the testimony of Officer Niels. And Niels is with APD. He's the one that went out and arrested Kaitlin on 5/12 on that old outstanding like 2018 misdemeanor theft of service warrant, when they were basically just trying to get her to come in and talk because Strickland was being interviewed in another interview room, and they realized that Kaitlin might have some more information, and they wanted to talk to her. So they go out and they pick her up. He says that he was wearing a tactical vest and had his gun on him at the time that he arrested her. And he said he knew that the warrant was not for homicide, but he actually was not sure what he was arresting her for. I thought that was crazy. He said that she seemed like she didn't know what was going on. Then Kofor asks how tall Niels is, and he says he's 5'8", and Kofor says like, oh, you looked bigger in the video. Tiny aside here though, when you have a witness come into court, every time that I've had a witness testify, like there's always a little room, or at least the lobby if there's not a room. But in this particular case, there was a room. Right before you walked into the main doors of the court, there was a room for witnesses where the attorneys were going in and talking to them before they got onto the stand. So like you go in there, you meet them, you know, size them up, right? Like literally in this case. Now, if Kofor did that, which I'm assuming he did before he started questioning this dude, then he would have known that this guy was only like not that tall, right? Kofor is a tall dude. So he should have noticed. So I'm thinking that like he must have just like left that question on his script and just forgot to erase it or go to the next question or something. Or maybe he was doing it for some other reason to like elicit an objection. I don't know if that was really his intent, but I think it might have worked out for him. So he asks the officer, like, you're muscular, right? And the guy says, like, yeah, on a good day, which gets people laughing in the gallery. And then it does actually elicit an objection from the state. And it was for relevance. And Kofor says, like, oh, this is relevant. I'm trying to show the jury that 2 big men with guns and vests drag her down to the interrogation room. She clearly doesn't know why she is under arrest. Of course she was terrified, which then gets another objection to the word dragged, and the state says no one was dragged, and then that's sustained, and he moves on. But point is, the jury got to hear that exactly what Kofor wanted them to hear. So I doubt that was like strategic on his part, because I haven't seen that level of strategy throughout this trial. However, it was good. It was good. Neil says that she actually didn't seem afraid. He said he drove her. So he arrested her and he drove her to the station, right? He arrested her. He put her hands behind her back and he put her in the back of the car and he drove her to the station. He also drove her home, like back to her house after the interview, and she wasn't in handcuffs because they had decided she wasn't under arrest and the warrant was no good, blah, 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 right? But he said on both occasions that they actually like engaged in small talk, which I thought was wild. Wild. He said that she just seemed like very indifferent about the whole situation. And then on cross, the state asked Neil to take a look at Kaitlin Armstrong sitting at the defense table and asks if she looks indifferent now. And he says she looks exactly the same as she did then on the day that he arrested her. So yes, I guess that means she looks indifferent. Now, in this case, the defense's DNA expert is going to have a pivotal role in rebutting the state's DNA. The state's expert presented evidence linking Kaitlin to the bike and therefore the crime scene. And the defense's expert is going to step in to offer a different perspective. What the defense's expert is going to do is they are going to create the possibility of transfer DNA rather than trace DNA. And this involves challenging the assumption that DNA found at the crime scene directly links the person that they're claiming, which is Kaitlin, to the actual crime. The expert will explore different scenarios where DNA could have been innocently transferred, highlighting the potential for secondary transfer rather than trace DNA, right? So they're going to, just try to create some reasonable doubt here and really offer an alternative explanation as to why her DNA might be on that bike seat and those bike handles or the handlebars. I mean, they have to do that. So they call Matt Quattaro. I know I said that wrong. He's a DNA forensic consultant. He's asked about the DNA on the bike, and he says that there was a tiny bit of male DNA on the handlebars, but that it was not enough to generate a full DNA profile. He also explains that the unknown, as to the unknown DNA, he says he can't determine whether or not it was one person, multiple people, or like the same person, right? So it could have been many people. He doesn't know. All he knows is that it doesn't match the 4 known profiles. Then they get into transfer with him, and he explains an actual case where DNA was transferred to the crime scene through transfer DNA via basically a middleman. He says it's possible for a person's DNA to be in a place that they've never been. And he also says that it's possible for a person's DNA to be on an item that they've never actually touched. He says that it is possible that Kaitlin's DNA could have been on Mo's bicycle without her having actually touched it. He explains that when you sweat, you shed more DNA, and a helmet being worn in the hot May weather could produce the circumstances conducive to sweating. However, on cross, the state points out the difference between probability and possibility, and they use the example of like winning the lottery, I think, and they say it's possible that I could win the lottery, but it's not probable. And apparently a lot of people thought that was like a good one. Then the state gets him to talk about DNA degradation under different circumstances. I think they're trying to hint at the swimming aspect here. but we don't get there. Next, defense calls a metal scientist. And this guy is going to be like the dude who rebuts the ballistics expert of the state. So the guy that's going to rebut Stephen Aston's testimony, which tied the bullets and casings found at the scene as being fired from the weapon that Kaitlin Armstrong owns, right? They say those were definitely fired from her gun. And so this expert's coming in, and I'm not going to go like crazy into his testimony because apparently it was like very boring and very long. And I'm not trying to have the longest, most boring video here. This one's already going to be boring enough because, sorry, defense, but y'all's case was boring. So I'm just going to tell you that he came in to basically say, if you watched any of the ballistic stuff that I did, or maybe if you went back and watched it on Valhalla or Making Law Simple, if you watched that one that I always link in the description that has Steven Gosney and Ian Runkle on there, they did a really good job of explaining basically what this dude's going to come and explain. And I think actually Gosney mentioned this guy. I feel like I heard his name. But anyway, he's going to come in and he's going to say that this is just junk science. And I agree with him. But I'm not sure that they needed to call this dude in order to get that point across, because I actually think that they did an awesome job of destroying that testimony during cross-examination. Joffrey Purrier did actually like an outstanding job of cross on that guy. So it was definitely the best cross that I saw from the defense the entire case. So I'm not sure that they needed this. I think it might have just like angered the jury and annoyed them. I think they probably could have picked all this up previously. So, and you know, this is important evidence for them for sure. Like this is something that definitely needed to be attacked, but I think they did it on cross. I'm like, you know, if you're going to present evidence, especially important evidence, and if you're going to put on evidence, like it should all be important, right? But you want the jury to be paying attention, because if they're not paying attention, then you might as well have not even put on the evidence, right? So, and they were not apparently paying attention. So anyway, this guy says that he is not, he's like not part of the AFTE, which is, he calls it a trade association and not a scientific association. And he doesn't agree with their standards. He says they really aren't standards. And he attacks them. He also gives examples, though, where they have incorrectly found significant agreement, that term that they use that really is hogwash. It means nothing. It's just whack. But it's what they use to make an identification. But he gives examples where that they have found significant agreement or sufficient agreement. I don't remember which one it is, but whichever one of those, in cases where the bullet was actually shot from a completely different gun. So like in cases where there should not be significant agreement or sufficient agreement or whatever it is. He also says that he doesn't agree with their standards for peer review. He says that they're terrible, and a better standard would be a blind process involving at least 3 other sources, which he refers to as refereeing. And if you remember Aston, he basically said like, oh yeah, you know, my buddy down there at the lab on the table next to me just performs the same test fires as me and confirms and signs off on my findings. And he also said that no one had ever disagreed with his findings, which I find highly suspect. So nobody had ever disagreed with his findings, yet he also admitted that this field is super subjective. It's a super subjective process, and that even his own standards, like his own standards differ within a case just as they differ from case to case and from like examiner to examiner. So really strange that nobody would ever disagree with him. This guy also said that, yeah, it's sufficient agreement. Okay, sufficient agreement. Yeah, he said it was like the most flawed and worthless statement and claim that he has ever seen. And he said that the AFTE methodology can't actually be called protocol. They're only guidelines that are imbued with fallacies of presumption. He basically is just there to debunk the theory on firearm and toolmark examinations, just in general. And he says that, like, so on cross, the state asks him about several articles and authors that they say are leading authorities in the field. And then the state says, so apparently, apologize. Apparently he had said that, like, the scientific field is unanimously behind him in thinking that this is junk science. And so they name off all these articles and all these authors that they say are leading scientists in the field or authorities. And then he says he doesn't know who they are. And then they say you should be more careful in saying the scientific community is behind you in questioning this field of forensics when you don't even know, haven't even heard of the leading authorities in the field. And then later they asked, Guillermo asked him, like, hey, are you looking at a computer screen right now? And he's like, yeah, I'm looking at one of the cases that you, or one of the articles that you quoted to me earlier. And he's like, okay, I understand that, but we're in the middle of a murder trial here. Like, you can't do that, man. Oh, because I forgot to tell you, because this guy, worst part about it, cannot believe I forgot to tell y'all, he is testifying via Zoom. I don't know if you remember, but I told y'all on day 7, part 2, that was like the most terrible testimony. Like, it was so boring until Joffrey started cross of the ballistics, like just a very boring subject to begin with. I cannot even imagine if that guy wouldn't have been in the courtroom, if he would have been on Zoom, because I had given up even taking notes on the witness. I was like taking notes on the people around me and the jurors and how many of them were sleeping. Like, Zoom was a terrible idea, right? So anyway, that was about it with him. And oh no, the state then went over some stuff with him, like just showing that previously he had contradicted himself in other articles and apparently in testimony before Congress. But like, this dude's been doing this forever, and like, he's been in the field for a really long time. So yeah, I'm sure he's changed his mind a few times. Anyway, this guy gets dismissed and they take down the Zoom screen, and then we get our next witness. And if you remember, so Colin Strickland already was on the stand during the state's case for 2 days, right? And at the end of his testimony, the defense put him on recall. They did not actually release him. So they left open the possibility that they would call him in their case in chief. And they made good on that. And they called him as their next witness. So the first thing that they asked him was about the motorcycle helmets and how many he had. He said he had 5 and that Kaitlin maybe wore 2 of them. And he said he doesn't recall the last time that she wore the helmet. Then Kofor shows him pictures of the gun cases, the guns, and the gun locks. And then they just hand them to the jury. Don't put them on the Elmo, because what is technology? But Colin said he couldn't remember ever buying the black gun lock, and he never put the black gun lock on any of the guns, and he doesn't know how the black gun lock got onto the gun. He also says that he doesn't remember the specifics of his interview on 5/17. He thinks he told Spittler about the vandalism to his house, but he's not sure. And he's like interrupting and saying, I don't recall a lot, to Kofor once again. It's very clear that he doesn't want to be there, but, you know, who can blame him? And Kofor then publishes a muted video of the 5/17 interview with Spittler, and you can see Colin in the video showing Spittler his phone. You can also see, apparently, Claire Carter, his attorney's high heel in like the bottom of the frame of this video. And Cofer makes a point of like calling it out and saying that's your attorney, right? And the only reason that I can think that he did that was just to like make sure that the jury is aware of the fact that Colin had the opportunity to go in and talk to detectives the second time with his attorney. And I guess they're trying to point out that Kaitlin didn't never get to do that. But we did get testimony at some point that once Kaitlin was brought back to the United States from Costa Rica, that Connor tried to go down there and talk to her then. And so, you know, Kaitlin could have talked to her then. And definitely, I mean, she was under arrest at that point. She definitely could have insisted that her attorney be there. And so, you know, Cofer could have gone down to Houston and talked with the detective with her. Or Cofer could have set up a time for when she was transported back to Austin. So that's probably why they didn't just like outright make that argument. But anyway, you can see Colin showing Spittler, like you can see him zooming in and showing him the photos on his phone. And then afterwards, when Cofer questions him about it, he says, yeah, he was showing Spittler the vandalism photos on his phone. And he says the reason that he showed them to Spittler is because he thought that they were relevant at that time. Then the jury is handed photos of the vandalism, and again, not put on the Elmo. It's pictures of the limestone pavers that were pushed over, and Colin says they weighed 30 pounds each, and he says the motorcycle that was pushed over was heavy, and that it would take someone of some strength to push it over. And if you remember, previously, Colin testified that Kaitlin never drove his motorcycle because it was too heavy for her to like handle, to move around and stuff. So that makes sense. He says that he does not believe that it was Kaitlin that committed the vandalism because she was at home most of the night, which I thought was weird. And then he made a point of pointing out once again, which he did like at least 2 other times during the state's case, of saying same house, not necessarily the same room. Like he just wants to make super certain that they're aware that they weren't in the same room the whole time. He says he didn't hear anything suspicious outside of the house and he was awake most of the night. And he says, I don't recall when he's asked about lying to Kaitlin when he was in a relationship with her. And then they point out the fake alibi. And he's like, oh, yeah, I didn't put much thought into that before sending it. And then he agrees that that was a lie. He also agrees that he deleted text threads. And then he's asked if he was honest with Mo Wilson. And he says he did his best. On cross, the state asked him if it was Kaitlin Armstrong that was driving the Jeep when she pulled into the driveway on 511. And he says, yes, it definitely was. And he also says that she never said that she had loaned her car to anybody that night. He says she owned her own helmet and that she wore her own helmet the majority of the time. Then Colin's dismissed. And then the judge calls Kaitlin up to the bench. And this happens in every criminal trial. It is a requirement. The judge has to get on the record whether or not the defendant wants to testify. Like the defendant has to make that decision. It is not the attorney's decision. It's not the judge's decision. So the judge has to make sure that that's on the record. And so they did that up there. Apparently, Kaitlin kind of had to be walked through this process though. Like Cofer said to her at one point, this is not a trick question. Which seems odd. Let's just leave it at that. But anyway, she apparently eventually said no, and then said, like, Alex from News Nation said that she mouthed sorry to her parents when she was walking back to her seat. So I don't know. So next, because the state has the burden of proof in this case, and in all cases, in criminal cases, they also have the right to put on a rebuttal case, and they chose to do so in this case. And they decided to call in a DNA expert as their rebuttal witness, and that was Dr. Tim Califut from Sam Houston State University, and he is a forensic scientist. He says he was given. Hold on a second. I'm still so stuffed. Okay, so Califut testifies that the state gave him two propositions. The first being that Kaitlin Armstrong's DNA was on Mariah Wilson's bicycle because Kaitlin Armstrong, with her hands, tried to dispose of the bike. Like, she took the bike and she tried to dispose of it, and that's why her DNA was on it. And then number two was that DNA was transferred to the bicycle through a series of activities, like Wilson picking up Caitlin's DNA through a motorcycle helmet. And he says, as to the second proposition, he says the likelihood of DNA being transferred after being picked up on a motorcycle or a helmet and then going swimming in deep eddy pool is highly improbable. And I would agree, like, I would agree, right? That does seem improbable. However, she also put the motorcycle helmet on and got on the motorcycle after she left Poolburger, and then she went back to the apartment. So she could have probably still transferred DNA at that point, right? And I don't think anybody ever said that she like completely got all of her hair soaking wet, unless I missed that when she was going swimming. And so I'm not sure that that's like the strongest one. I'm not saying that I think that it was transfer DNA. I don't. I'm not sure about that one. I still think it was Kaitlin, but I don't know about the DNA. He says he would not expect to find DNA further down the chain in that case. And he then says that that's like 4 transfer events and that he's only ever heard of 2 studies. I mean, still, there's 2 where that it's been passed down 4 times. And then he says that in those cases, the DNA had to be highly amplified in order to survive. I have no idea what that means. He confirms that he doesn't have any information about the third unknown donor found on the bike. And he says that there's no way to tell when that DNA was deposited, whether it was before 5/11 or on 5/11. And I think that's kind of a crazy thing to say because, again, the state had Kaitlin Cash. They recalled her to the stand to come back after they had released her, come back and testify specifically about the fact that Mariah Wilson always washed her bike like really well. She was very strict about it. She always washed her bike after a hard ride, and she had a hard ride on that day, and she likely washed her bike, and she used, actually, maybe she said it wasn't a hard ride. But the impression was that she had washed her bike that day, right? They even asked what she would use. And Kaitlin Cash said she would use cleaning solution and water. And so if this dude is saying that DNA can't survive swimming in deep eddy pool, which is like a natural spring-fed pool, then I highly doubt DNA can survive cleaning solution, right? Maybe that's just me. Also, I know nothing about science, so who knows? But anyway, his opinion is that it's more likely that Kaitlin Armstrong placed her own DNA on the bicycle, so trace DNA, than Mo transferring Caitlin's DNA by accident or through transfer. On cross, the defense just makes sure to get Califut to say that it's possible, like in the world of possibilities, it's possible for DNA to be transferred. Not in this case, just it's possible in general. He says he was brought into the case 3 weeks ago. And then on redirect, and he also says he reviewed as much of the case as he could, like that he was given. And then on redirect, the state asks if he knows anything about the case, and he says he knows the basics. And that's it. That's the end. That's the end of this case. Woo! Okay, so we're already at 34 minutes and 25 seconds. So I'm just going to try to hurry and speed this up really quickly. But as you know, I have been recording these way after the fact because RSV, my ear is still completely stopped up. And so we already know the outcome. The state did an incredible job in this case, but to be fair, they had like the easiest case ever. I mean, it would have been highly embarrassing if they had messed this up, which they didn't. I can tell you now, they did not. She was convicted. She was found guilty. And I think, you know, everybody saw that coming. And she was also sentenced to 90 years, which is an incredibly long amount of time. I'm not saying she doesn't deserve that. However, it was shocking. It was shocking. I was shocked. I was visibly shocked. I was on LegalBytes stream when I heard the 90, and I like, for sure, I had a shocked face. I do not remember the last time that I heard of a sentence that long in Travis County, and maybe I just haven't been paying attention, but that seems incredibly long to me. But, you know, it is what it is. At some point, I plan on doing like a stream or a recap of the closing arguments, and then also on the punishment phase of the trial, which they, you know, in the punishment phase, they also have witnesses come in and testify. And so those I just followed on Twitter because RSV. And yeah, so I don't have any like firsthand knowledge of that. I can just like give you my thoughts on it. And I have so many thoughts. But anyway, I did go on LegalBytes stream for closing arguments and for the verdict. I actually missed the verdict, but still ended up on the stream. And then I also went on not for the closing of the punishment phase because I was in bed sick, but I went on for the verdict of the punishment phase. And I will link those down in the description. I am sad for everybody involved in this case, especially for Mariah Wilson's family. It was very tragic to watch her family every day in trial. I felt very sad for them, but they were so brave to come in and, you know, seek justice for her every single day, even though it had to have been incredibly difficult to do so. And she had so many friends and just so many people that loved her there, and that was really great to see. Very sad also for Colin. I know a lot of people disagree about that, but like his life has also been greatly affected. And that's very clear. And on the last day that he testified, he actually had like his emotional support dog with him. I don't know if that's the reason that he had it. He had a dog in the courthouse, and they don't just usually let you have your dog in the courthouse unless it's like an emotional support dog. And they do allow that for people that are testifying as witnesses in cases. And a lot of times you see that in, like you see it a lot with child witnesses. But I mean, I'm not saying that it's just for children. It's absolutely not. I'm super glad that he was able to bring his dog. And I hope that it brought him comfort, because it was very clear that he was uncomfortable being there and that he had been through a significant amount of trauma in this whole experience. And I hate that he had to relive it all. And then obviously Kaitlin has, like, you know, she threw her life away. And I mean, yeah, she's going to be in prison for like ever. I think that she is eligible for parole in 30 years. And I don't know how old she'll be in 30 years, but it's a long time. And so, yeah, if you've stuck with me or if you've enjoyed this at all, thank you. I've really enjoyed being able to get to learn how to do these videos and having people watch them and comment. It's been super fun. I plan on doing more things on my channel. Obviously, I'm a criminal defense attorney, so I plan on covering a lot of criminal trials, but also just trials in general. I just love trials, and I am constantly watching trials. So that's what I plan on doing. But if you have anything specifically that you would like for me to do, I'm like game to do it. I think I'm going to be doing some live streams here soon, probably in the coming week. I know that the Young Thug trial is going to be going on, and I'm super interested in that. I'm not sure, like, it's supposed to go on forever and ever and ever. And so I'm definitely not going to be covering all of it because I do have a full-time job being a criminal defense attorney, and I am also a mom. So, you know, I won't be able to cover it like all day, every day. But thank you so much for sticking with me and for watching. And please, if you haven't already, subscribe, definitely like and share, do all the things, and come back. Thanks, guys. Bye.